Hello, everyone. Welcome to the LGB Alliance USA News Roundup for the week ending on June 20th, 2025. Today, we are focusing on the Supreme Court's 6-3 decision on June 18th in favor of the state of Tennessee in the U.S. versus Skrmetti case. Just as a brief overview of the Skrmetti case, the government of the U.S. sued the state of Tennessee, whose attorney general is named Skrmetti, over its ban on pediatric gender transition, including the use of puberty blockers and hormones. The U.S. government, aided by lawyers from the ACLU, argued that the Pediatric Transition Bill, called SB 1, violated the Equal Protection Clause of the 14th Amendment. By ruling in favor of the state of Tennessee, the Supreme Court has decided that SB 1 does not violate the Equal Protection Clause and hence can stand as the law of the land in Tennessee. In other words, this ruling gives the okay for states to enact bans on puberty blockers and hormones to treat gender dysphoria for minors. Now that's the summary. Let me break down the majority opinion, which was written by Justice Roberts and joined by the rest of the court's conservative bloc. The decision tackled three main arguments that the plaintiffs used against SB 1. First is the argument that SB 1 warrants heightened scrutiny because it relies on sex-based classifications. So here the plaintiffs argue that SB 1 enforces sex stereotyping. I guess one possible example of this would be assuming that girls shouldn't have facial hair and hence not allowing girls to get hormones to allow the growth of facial hair would be considered a form of sex discrimination, according to this argument. Roberts, however, rejected that argument, pointing out that the Tennessee law proclaimed, quote, legitimate, substantial, and compelling interest in protecting minors from physical and emotional harm, unquote, and that Tennessee found that these banned therapies are experimental. In other words, the state of Tennessee was not enacting the law according to sex stereotyping, but due to legitimate medical concerns. Second is the argument that SB 1 warrants heightened scrutiny because it discriminates against transgender individuals, whom the plaintiffs argue constitute a quasi-suspect protected class. And this is important because if SB 1 is subject to heightened scrutiny, it would give the plaintiffs more weight to argue that the law is indeed unconstitutional. Now, Roberts rejected this argument because SB 1 does not categorize according to transgender status, according to Roberts. Instead, SB 1 categorized based on two things: age and whether or not the medical treatments are prescribed to treat, quote, gender dysphoria, gender identity disorder, or gender incongruence, unquote. And Roberts argues just because only transgender people are minors seeking treatment for gender dysphoria, gender identity disorder, or gender incongruence doesn't mean that all transgender people are minors seeking treatment for those conditions. Hence, the law doesn't discriminate against transgender people. The analogy here is given with pregnancy. There was another ruling, Gerulig versus Alieo, which decided that a California insurance company is not discriminating on the basis of sex by excluding certain pregnancy-related conditions from its disability coverage. The idea being that the law differentiated between, quote, pregnant women and non-pregnant persons, end quote, and since women fall into both groups, the law doesn't discriminate on the basis of sex. Since SB 1 does not discriminate by transgender status, then it's immaterial whether transgender individuals are a quasi-suspect class deserving of heightened scrutiny. And so the court doesn't bother ruling here on whether transgender individuals are, in fact, a quasi-suspect class deserving of heightened scrutiny. It just says that question is irrelevant because the law doesn't even deal with transgender. Third is the argument that SB 1 violates Bostock versus Clayton County. The 2020 Supreme Court ruling that firing someone for being gay or transgender constitutes sex discrimination according to Title VII. Roberts says that he will not, and will not here, rule on whether Bostock even applies to this case, or any case outside of a Title VII context. Title VII is a federal statute, but this Skrmetti case is about constitutional law. But even if Bostock does apply to constitutional law, Robert reiterates the first 2 points he made, namely that SB 1 does not discriminate according to transgender status or sex. So, for example, a transgender minor could still receive puberty blockers for, say, precocious puberty, just not for gender dysphoria, which would be banned in SB 1. SB 1 is banning certain treatments according to a patient's particular diagnosis, including gender dysphoria, not the patient's transgender status or sex. Hence, Bostock wouldn't apply. So, according to Roberts' majority opinion, since SB 1 does not discriminate according to sex or transgender status, it should not be subject to heightened scrutiny. Instead, it should be subject to a rational basis review, which is a much lower standard of scrutiny that makes it much harder for the plaintiffs to prove. Now, like I said, the majority did not rule on whether Bostock even applies to cases like this outside of Title VII, and related to this, it didn't rule on whether transgender status actually constitutes a protected class. However, in addition to the majority opinion, there were 3 concurrences written. A concurrence, for those of you who don't know, is when one or more judges agrees with the majority decision, but on different or additional grounds. And these concurrences do address these questions about Bostock and transgender as a protected class. One concurrence was made exclusively by Justice Thomas. In the first part of his concurrence, Thomas argues that Bostock does not apply outside of Title VII and also argues that Bostock was incorrectly decided. So while the majority opinion punted on the question of Bostock's applicability outside of Title VII, Thomas conclusively argues no. In the second part of the concurrence, Thomas skewers the plaintiffs for giving too much credit to medical consensus and expertise. He does a tour de force about the bad science behind puberty blockers and hormones for gender dysphoric youth. He references the CAST review and points to how progressive countries like Finland, France, Sweden, Norway, the Netherlands, and Britain are backing away from pediatric transition. It is a refreshingly well-researched concurrence, but it is just that, a concurrence, meaning it's not part of the majority ruling and hence doesn't have actual legal weight. The next concurrence was written by Justice Amy Coney Barrett, and Justice joined this one as well. Barrett's concurrence argues that transgender status is not a protected characteristic. Once again, this was a question the majority decision itself punted on. Barrett points out that it's been 4 decades since the courts have added new constitutionally protected classes, and so already the plaintiffs face an uphill climb in adding transgender status to these protected traits. She agrees with the lower court, the Sixth Circuit Court's decision, that transgender status is not protected. Transgender status, Barrett explains, is not immutable or ascertainable at the moment of birth. She also points out that the transgender population is not a discrete group, and that it's very hard to define what transgender even means. Additionally, she writes that, quote, holding that transgender people constitute a suspect class would require courts to oversee all manner of policy choices normally committed to legislative discretion, unquote. She goes over similar points that Justice Thomas brought up, albeit more briefly, to talk about the scientific problems associated with medical transition and how various Northern European countries are scaling back on youth transition. She also talks about the problems implementing transgender status as a protected class. For example, how courts will be forced to interfere in legislation regulating sex segregation in bathrooms and sports. Barrett says that these factors, that is, the inability to define transgender as a discrete group with immutable qualities, are enough to rule out transgenders as a suspect class. But she also brings up a second argument that the transgender population has not been subject to discrimination as a historical matter. She says that discrimination according to private animus, say discrimination in employment or healthcare, isn't enough to make a class of people a protected class, a quasi-suspect class. But rather, we must demonstrate that that class of people has been discriminated against in the law. In other words, de jure discrimination. De jure discrimination would include, for example, laws that denied women the right to vote, or California legislation explicitly limiting the rights of Chinese immigrants. And there's no evidence in Barrett's view that transgender people have been subject to de jure discrimination. Hence, transgender people do not constitute a protected class. Finally, we have Justice Alito's opinion, concurring in part and concurring in judgment. He agrees with the majority opinion that SB 1 does not discriminate according to sex. However, he disagrees with the majority opinion's verdict that SB 1 does not discriminate according to transgender status. For Alito, it's irrelevant whether SB 1 discriminates according to transgender status, and he doesn't think the court should have attempted to rule on that question. Because Alito, like Barrett, does not think that transgender people constitute a quasi-suspect class deserving of heightened protection. And his reasoning seems very similar to Barrett's, pointing out that the courts have been reluctant to expand the category of protected classes deserving of heightened scrutiny beyond race, sex, and national origin. That transgender people haven't faced de jure discrimination, and that transgender identity is not immutable or discrete. Now, moving on to the dissent. Written by Justice Sotomayor, which Justices Jackson joined and Justice Kagan joined in all but Part 5. I'm not going to go into depth, but sections 1 through 4 contain Sotomayor's argument that SB 1 does in fact classify by sex and by transgender status, and hence does demand intermediate scrutiny, which is the same standard used in sex discrimination cases. So she's arguing that transgender should be a special protected class according to the law, and also affirms that this law relates to discrimination according to sex as well. And so this should all demand heightened scrutiny. Part 5 is what Kagan refused to sign off on. And Kagan, in her own dissent, explains why she didn't agree to that part. She says Sotomayor's dissent was correct in saying that it's proper to subject SB 1 to heightened scrutiny. She writes, quote, "More concretely put, heightened scrutiny reveals whether a law is based on overbroad generalizations, stereotypes, or prejudices, or it is instead based on legitimate state interests, such as the one here asserted in protecting minors' health. Because the court is wrong in not subjecting SB 1 to that kind of examination, I join parts 1 through 4 of Sotomayor's dissent. I take no view on how SB 1 would fare under heightened scrutiny, and therefore I do not join part 5. The record evidence here is extensive, complex, and disputed, and the Court of Appeals, because it applied only rational basis review, never addressed the relevant issues. Still more, both the plaintiff and the government asked this court not to itself apply heightened scrutiny, but only to remand that the inquiry to the lower courts. So I would both start and stop at the question of what test SB 1 must satisfy, and as Justice Sotomayor shows, it is heightened scrutiny. I respectfully dissent." Unquote. What I think this means is that Kagan is trying to leave some wiggle room for the possibility that laws like SB 1 could pass muster after it's put to the test of heightened scrutiny. she doesn't want to chime in one way or another on the question of SB1's ultimate constitutionality. She just thinks that SB1 should, in fact, be subject to heightened scrutiny first before any verdict on the constitutionality of the law is reached. So that's my summary of Skrmetti. Of course, there's a lot more that could be said that I'll leave for legal experts. There's a great diag space that I would recommend listening to. And I know a lot of people in the gender critical sphere were impressed by Justice Barrett in particular. Kara Dansky, for example, said on X in that diag space for Democrats for an Informed Approach to Gender that she was actually kind of disappointed in Roberts because unlike the lower Sixth Circuit Court, he didn't rule on the question on whether transgender people constitute a quasi-suspect class. But Dansky said that Barrett's concurrence was her favorite opinion because she did dismantle the argument for transgender as a special suspect protected class. And given that Barrett seemed to waver a bit in the hearings, it was pleasantly surprising that she delivered such a forceful opinion in the end that went above and beyond what Roberts' majority opinion was arguing. So that's one sort of take on this, that on one hand, it was a victory for the more gender critical side, that the Supreme Court ultimately ruled in favor of the constitutionality of Tennessee's pediatric transition ban, but ultimately was a bit of a letdown in that it did not resolve the question about whether transgender actually can be a protected class. And so, Joss, I'm curious if you had any thoughts or questions.
That was a really amazing breakdown of the Supreme Court decision, and I'm really grateful that you took the time to go through all of that and get that information. Thank you so much for that. I do have some questions. So one of the questions that I have, and we also had a number of questions that came into us from supporters that were curious about the case and the implications, was about the impact of this case on other trans cases or other types of cases wholly unrelated to trans in this one question. In particular, thinking about other states that have similar legislation, what would the impact be of this decision on those other states?
Yeah, that's an interesting question because, like I said, the Supreme Court was actually a bit cautious in this verdict about keeping the focus on the constitutionality of Tennessee's law in particular and not ruling on the ultimate question about whether transgender status could be a quasi-suspect protected class. It also was a bit cagey about what exactly the scope of the Bostock ruling was. So, in some sense, it might not actually tell us as much as we would like to know the way it currently stands. However, one thing that I noticed reading these opinions is that it it seems like the Supreme Court, the way Roberts was navigating this, he kind of was inclined to like not even think about transgender if he didn't have to. So like he made a big fuss about how the law as written was focused on age and gender dysphoric status and not on classifying people according to transgender status. So if you have laws on the book that might not directly talk about transgender, it could be that the Supreme Court will find ways to make sure to not read transgender status into the bill or find clever ways around making a particular bill about transgender status per se, because it sounds like the court is a little bit reluctant to go beyond there. So that's one possible thing that could happen.
Did they define trans anywhere, or transgender, or gender dysphoria? Did they use any concrete definitions around any of these terms?
No. This was a point that was brought up, I think, in both Barrett's and Alito's concurrences, that there really was not a good definition of transgender, and that's a problem. And also like I was saying, it's consistent with Robert's idea that he doesn't even really want to talk about transgender directly. In regards to language, I would say the Roberts verdict was pretty politically correct, let's just say, about saying language like transgender girls as being actually the male to female, the trans-identified males, calling them transgender girls. And I think also using language like child sex changes, which I think, if I remember correctly, Barrett did not use that sort of language. So Roberts, he sort of dodges this whole question of definitions and sort of just uses the whatever PC speak. While Barrett was the one who really tried to draw attention to how much of an issue it is that we can't define transgender.
I'm really glad that she put that as part of her concurrence because to me, that it's really problematic when people in positions of power and authority just use the language that's provided to them by groups like the ACLU they don't define. In the whole thing in Skrmetti in December, it was just really danced around. So I'm glad that Barrett made that distinction. So, question about the precocious puberty issue, where trans-identifying individuals could get puberty blockers for an issue like precocious puberty. Is and I am cynical, so my brain just immediately went to this spot that this would be a loophole that could be exploited by doctors and families to make a claim that a trans-identifying young person is really just going through precocious puberty and we need to get them on blocker stat. Are your thoughts about, maybe you're not as cynical as I am, but what are your thoughts about the potential of the exploitation of that loophole?
I honestly hadn't thought of that, but it's an interesting point. That would be, I would assume, in violation of medical ethics to give to sneak a drug that was supposed to be for one condition, but give it a different label. I think that would be technically illegal. And I think that would be something for like medical malpractice lawyers to deal with more than the Supreme Court.
To me, I think of the ways that we've seen these individuals and groups try to circumvent whatever is there to try to protect and put barriers on medicalizing or in the case of sports. We saw in Nebraska push to change the language in their bill around sports to remove the term biological. And that is therefore becomes a loophole where trans-identified males could participate in sports if they got their birth certificates changed to say that they were female because the wording around Kathleen Kauth's bill had biological included, and then there was a push to try to remove that word. And I think subsequently it has been removed. So that creates a loophole situation. So I'm just always thinking like in the background, they have these loopholes in mind and they're trying to figure out how to exploit them. So but it is definitely my cynicism. Another question from one of our supporters is what is meant by discrimination not according to sex in the gold dig? Since only women can get pregnant, why is it not sex discrimination given that it's fairly common experience for women?
Yeah, this was an interesting one that I hadn't heard of this case before, but apparently the logic here was some woman or women had a disability that was induced by pregnancy and the insurance company refused to cover it. And so the woman sued for sex discrimination. And the Supreme Court said, no, that was not sex discrimination because the law itself was not differentiating between men and women per se, but rather women who are pregnant and people who are not pregnant. And just because all the people in the first category, that is pregnant women, are women, there are also women in the other category, namely people who aren't pregnant, and hence it's not about sex discrimination according to the Supreme Court. when I saw this, my gut reaction, and I'm curious to hear what some legal experts would say on this, particularly those who are more into feminism and such. I'm curious how this might impact women's rights in other fields, because it seems like what the Supreme Court is saying is unless something literally explicitly discriminates against women, it doesn't really count as sex discrimination, even if it deals with something like pregnancy that's so inexorably intertwined with being a woman. I guess this has to do with maybe the Supreme Court's a bit skeptical of these sort of disparate impact cases, where if a particular policy isn't explicitly discriminating against a group, it just happens to be that a particular group is disproportionately impacted. It sounds like the Supreme Court is not really so interested in hearing those discrimination cases, I guess. So I think kind of stepping back to about the overall picture I got when I read this case is that the Skrmetti case in general is I don't really get the impression that these justices are all that interested in leaning into the sex discrimination or the women's rights angle to this whole question of transgender and gender ideology. I don't think that was something that, aside from maybe Justice Barrett giving that little aside about like, well, this could have a bad impact on like women's sports. I don't get the impression that the conservative majority was really leaning into that angle all that much, which could be a cause for concern for people who have been fighting this fight more from a feminist point of view. And so I'm curious what feminist lawyers make of that.
A follow-up to that question is, what do they mean by this is not medical treatment? What does that mean for WPATH?
Yeah, that's an interesting one. It sounds like it was Thomas in particular who really, really did not like this idea of medical expertise being the idea of politicians have to defer to medical expertise. And I don't remember if he called out WPATH specifically. I would assume he probably would have because it was actually a pretty in-depth concurrence. So he at least is not so excited about the idea of deferring to groups like WPATH. And it sounds like, in general, the conservative majority is not buying this idea that some group like WPATH has this unlimited authority to set the standard for what should be legal medical care, and that they're willing to give some weight to politicians to, in some cases, override what politicians at the state level, at least, to override what groups like WPATH think. So it does, I guess, curtail WPATH, at least their influence.
Which it is a really good thing because with WPATH is not certified by any outside source that I'm aware. It's just a group that came up on its own and has just been giving its opinion all over the place and then affecting law. And that's really a scary proposition, especially when the things that they have advocated for do curtail the rights of women, LGBT people in particular. Yeah, so that's a good sign.
Another point along these lines is I do think it was interesting how at least a few of the concurrences, particularly Thomas's, used the example of other countries' medical authorities, like the Cast Review, and bringing up the Netherlands and the Nordic countries and their approaches. I'm just curious about that because I remember once when discussing the Skrmetti case with someone else last year, a guy from the UK, we had this discussion of like, well, can the cast review really impact things in the United States? Is there a precedent for using other countries' medical practices here in the US? And it seems like at least a few of the justices are inclined to do that, even when it would override the practices of American medical groups. I think that was interesting.
It is interesting, and American medical groups have pulled already from European sources to talk about the protocol. The fact that we have this really did spur from those initial cases in the Netherlands. So they were already pulling. It would just be fair and balanced in that way for the CAS review to have an impact as well on what happens here if we're already felt the impact from the protocol, which there wasn't the long term. We didn't, they just took this information on, they took the gender medicine on, and there was no long-term implications or studies at that point anyway. So they just took it on face value that this is how we're going to treat gender medicine now for the youth, and it's obviously had deleterious effects.
Yeah, that's a good point.
We mentioned the other states, the way that this could be applied to other states.
Yeah, and I was listening to that Diag X space, and one point that was brought up was strictly speaking, Tennessee's law only talked about puberty blockers and hormones and did not talk about surgeries for minors. So technically speaking, they did not rule on the question of whether surgeries would be laws against minor transition surgeries would be allowable or not. But I have a hard time believing that. I feel like that might be a bit of a hair split sort of thing here because I have a hard time seeing a case made that like it's okay to ban hormones and puberty blockers for minors, but it's not okay to ban surgeries. That would be a very odd position to hold. And the other another point is that I also recall in the diag thing, and I think this was also brought up when we were talking with Candace and Glenna last time about it, which is that theoretically there could be other lawsuits brought against pediatric transition bans on other grounds. Like this doesn't guarantee that the ACLU or whoever else isn't going to try again to challenge the law. So, but who knows how they're going to do that? I know there are some people who are very angry at the ACLU who are on the pro pediatric transition side because they think Chase Strangio from the ACLU did a very poor job at arguing the case and that this unintentionally set back transgender issues by doing such a poorly thought out case. So who knows what the ACLU's next move will be in these state bans.
I hate to say a phrase like props to Chase Strangio. Like that feels weird coming out of my mouth, but I don't know that she could have really given any better or different arguments. I think it's kind of just throwing her under the bus in this case by trans activists to say that she did a terrible job with the case. Like they gave her a lot of talking time. She had a lot of opportunities to get all of her points out. And there's a lot of back and forth. Like I'm sort of surprised by this decision in a way because of how much room there was in the discussion and the back and forth between the justices and especially Chase. So I'm glad to see that, but I really do think, fair play to Chase. She gave it her all. Like it's hard to make a sound argument around something that's completely illogical and has no basis in sound arguments. Like how do you take an apple and describe it as an orange and make it make sense? Like you can't do that. Maybe that's a bad analogy, but I just I think she's getting kind of thrown under the bus here.
Yeah, it's an interesting point. I guess maybe, and I'm just trying to steelman the pro-trans, anti-Chase argument here. Maybe you could make an argument that they shouldn't have filed this lawsuit at all, or like they shouldn't have tried tackling pediatric transition at all because it's an issue that's so unpopular and weak for the pro-trans activist side. And that maybe they should have tried a case that's more sympathetic to the trans side and then use that as a legal precedent to build other cases. That's kind of what happened with Bostock, actually. Like they took a case where, they had a trans, I think was it a trans identified male who just wanted to wear women's clothing on the job and wasn't allowed to, which is, in some sense you could make a perfectly sympathetic case for that, regardless of whether you feel about trans per se. You could say, well, why should employers impose these dress codes? And that ended up fueling, by ruling in favor of the trans employee, that ended up strengthening transgender rights, I guess you could say. And we're now dealing with the repercussions of that. So it's possible that the problem here is they shouldn't have used this particular case of pediatric transition at all. They should have tried something else. Maybe trans in the military or something where people aren't as 100 per, not, aren't, it's not like an 80-90% of the population disagrees issue or something.
Yeah, no, that's a very fair point that they may have done better on trains in the military. But I think that it's just kind of the way that it comes from Chase in particular, but the ACLU in general is that there's all of these rulings and all of these laws all over the place, and they have to fight them all. And they have taken this whole notion of youth, trans youth on their shoulders as this class that they need to protect. So I think it maybe wasn't even a thought that they wouldn't get the sympathetic ruling that they were hoping for in this case because of how lost in their own delusion they are. I hate to kind of just put it so frankly, but yeah, I think sometimes people have too much confidence because they believe so much in their really incorrect position. Maybe that's why they decided to take this one on. In the babies, it's always about like save the babies. And for them, saving the babies means medicalizing them. So and to the point about this speaking just to puberty blockers and medical transition, but not surgeries. I think that it's kind of the smart avenue that Tennessee took here because it should be that if you can't do one, you can't do any. Because how do you go from you have this trans identifying child and we're gonna skip blockers, we're gonna skip cross-sex hormones, we're gonna skip any kind of medical intervention in that way, and we're gonna go straight to surgeries. That's a big jump to get there. So I would think just based on medical ethics, you wouldn't just go and do a double mastectomy on a 13-year-old because she can't get blockers and she can't get cross-sex hormones to affirm her gender. Hopefully,
Yeah.
that would put a stop to that.
Yeah, I would think surgeries would be even more extreme and more controversial than the hormones and blockers.
After reading through all of this and you listen to the Diag Twitter space, which we encourage everyone to listen to as well.
Yeah, so we do recommend the Diag space, which had retired Justice Elspeth Cipher, attorney and author Kara Dansky, and attorney and writer Glenna Goldus.
Yeah, definitely check out that space. A lot of the questions that we got, they covered in those spaces. And Glenna also wrote about it on her Substack. She has quite an extensive write-up about it. After reading the Substack, listening to the space, reading through the arguments, the concurrences, what are your big takeaways or your through line feelings or thoughts about this decision?
I would say I'm broadly unsurprised in that I expected, and I was talking to some other people about it recently, that I expected the Supreme Court would rule in favor of Tennessee. Probably the conservative bloc would rule in favor of Tennessee, but that I didn't think it would be like a 100% slam dunk, that they were probably going to leave some ambiguity or something in there. And that's exactly what happened with refusing to rule on the question of whether, transgender is really a protected status, about whether, what's really the scope of Bostock. They did leave those unanswered questions, and I'm curious if and when the Supreme Court is finally going to tackle those questions because they're kind of important, and it does seem like a bit of a dodge to punt on them. And this was also, something too that I think Glenna Goldis maybe or someone in the Diag space brought up too, that in some sense Sotomayor in her dissent was right that it's a bit disingenuous for the court to say, let's not talk about transgender status in the law, that it's a bit of a cop out. So I'm curious how what court, if that's ever going to settle. And the other thing too is that I wasn't sure about going into it was, which justices were going to be, assuming the conservative bloc broadly was going to side with Tennessee, which justices were going to be the most decisive and squishy. Uh, and one thing that surprised me was that Justice Barrett, who I kind of thought would be in the squishy camp, turned out to be one of the more decisive justices. If you were listening to the hearings, Justice Barrett wavered a bit, and I remember Candace Jackson and I were talking about how she seemed like a bit of a disappointment in the hearings, but she really came down against gender the whole thing. And so she might end up being one of the leading voices on the courts against gender ideology. While as Thomas and Alito, as expected, were pretty decisive against it. The question is between Kavanaugh, Roberts, and Gorsuch. They seem to be more cautious. And so I'm curious to see what they end up doing in future cases.
Thanks, Ariane, for going through all of that research, and I really appreciate your analysis of this case. And I want to just update our supporters about our groups. We have a number of groups that we run every month, and we have two new groups actually that I want to tell you about. We have our bisexual women's group is the last Wednesday of the month at 8 p.m. This is for bisexual women only. And we also have a new group. The first meeting will be August 23rd at 7 p.m. And this is a gaming group. So this is just to come together, have fun, and do some lighthearted gaming together. So look for those events on our calendars page, lgbausa.org/upcoming-events, or just go to the website. You can find the links there. Please join us for any of those meetings that we have. And just a note, to register, you need a verified Zoom account. So that means you go to Zoom, make a free account, and then authenticate that account in email, and then you can register using those same credentials for any of these events. We encourage all of our supporters to participate in the meetings and get to meet other people who are gender critical and LGB.
Thank you, Joss, for that plug. And thank you, Joss, for the conversation. And thank you, everyone, for watching. We hope to see you again next time. Bye.